Good morning. Happy Monday. So I was blessed by another couple of comments from the Sov sit, and he just can't help himself. The first thing he tells me that I'm wrong on Bivens and that the Constitution is a source of things to sue on. And no, it's very limited. Just like I said in the video, it's very fucking limited, super limited. The only ones I'm aware of are you could sue under the 4th and the 5th Amendment, under Bivens, and another case I don't remember, if someone is acting under color of federal law, and you can only sue a person. You can't sue the government. So you can sue a person who violates your rights under the 4th or 5th Amendment, acting under the color of a federal law. Very limited. Super duper limited. And considering that up until Friday, this guy had never even heard of the Bivens case, and he still doesn't understand it today, I'm not really terribly concerned with what his opinion is on the Constitution being a source of law. And it doesn't even give you the right to sue. You already have the right to sue, even under Bivens. They discuss having the right to sue, and you already did have the right to sue. The thing in Bivens is you can only sue for declaratory or injunctive relief because Congress authorized that. 28 U.S.C. 2201. We'll go with 2201. It's 2201 or 2202 or somewhere in there. Anyway, if you're interested in looking at the congressional authorization for federal courts and who gets to sue and what stuff, it's 28 USC. 18 USC is for crimes, 28 USC is for federal courts. Anyway, where was I going with that? So you could already sue for declaratory or injunctive relief. Bivens just said, well, instead of making them file in state court and then removing it to federal court, we're just going to let them file it here. And I don't really understand it. I don't really agree with it. It seems like they're making federal common law, but hey, I just report the news. I don't write it. So then, just to prove that he doesn't understand a damn thing about a damn thing, he goes on to ask me, so what would you do if, and that's always a dumb question. That's a dumb way to start a question. What would you do if, let's start a revolution. But what would you do if Congress repealed 42 U.S.C. 1983 and then passed a law saying that you couldn't sue the federal government over a violation of the First Amendment? And first of all, again, 42 U.S.C. 1983 does not allow you to sue the U.S. government. It does not. There is no provision in it for you to sue the U.S. government. You cannot sue the U.S. government under 42 U.S.C. 1983. Can't be done. Cannot be done. And you can't sue the federal government over political questions. That's one of the ramps. That's one of the ripeness, mootness, political questions, standing. That's one of the ramps deals. Anyway, if it's a political question, if Congress passes a law, unless it's a violation of the Constitution, you can't bring a suit over it. Now, what would I do if it's just a dumb question. It's just a dumb question. Anyway, even if Congress got rid of 42 U.S.C. 1983, you still have an outlet for declaratory and injunctive relief. There is separate statutory authorization for that. All 42 U.S.C. 1983 allows you to do is allows you to sue for damages against someone who violates your rights under color of state law or District of Columbia law. That's all 42 USC 1983 does. you could always sue for declaratory relief under a completely different statute. But again, it's a statute that's authorized by Congress. And it's been that way from the get-go. One of the very first cases that you read about, Marbury versus Madison, they're dealing with the Judiciary Act of 1789. And the Judiciary Act of 1789 set up the Title III courts that Congress got to set up, the lower courts. It set up the questions they could answer and how they could answer them, etc. And the issue that it was dealing with in Marbury versus Madison was whether or not the writ of mandamus that Congress created to send questions directly to the Supreme Court, and the Supreme Court ruled that that was unconstitutional, thus basically saying that it's the courts who determine whether or not things are constitutional, etc., etc., etc. But my point is that just in the question, the guy shows he doesn't understand what he's talking about, and his blathering on about the Constitution being some sort of a font of tort action is also just nonsense. It's very limited. And again, there's already a right to sue, even before Bivens, a statutory right to sue for declaratory and injunctive relief. Individuals. Bivens just allowed you to sue individuals for damages. It's not for suing the federal government. You still can't sue the Department of Defense for what happened to Freeman. Thanks for watching. Have a great day.